Our next case is W.H. Minor versus Akron City School District Board of Education. Are we all ready to proceed at this point in time?
Yes, Your Honor.
All right, very good, thank you. As you know, the argument will first each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
5 minutes, please.
Thank you. I will note that, counsel, as you look over there to your left, you'll see the times up there. We'll be just using the top one for you, so that'll be counting down from 15 to 5. When you see it 5, then you're in your rebuttal time. I'll let you try to about a minute early. If you keep talking after that, that'll just come off your rebuttal time. And Mr. Gilbert, you're that middle circle there for you.
Thank you.
The arguments are being recorded, so when you come up, please introduce yourself. Make sure you stay behind the podium so we can see you on the recording, and make sure that you speak loud enough so we can hear you. As we have some minors in this case, please make sure you refer to them by initials rather than their full names. With that, we've read your brief and ready to proceed with our brief. Thank you.
Good morning, and may it please the court. My name is Matthew Smartnick for the appellants in this matter. 4112.02G does not expressly convey liability against a political subdivision. The plain reading of the statute clearly shows that the only individuals that can be liable for this violation of the statute are proprietors, employees, keepers, or managers of places of public accommodation. For that reason alone, the city or the school district is immune under 2744.02B5.
Did our prior appeal discuss that issue?
It does discuss that issue. It was determined when we were here last time that the trial court needed to finish the analysis under 2744, specifically looking at .03 to see if immunity was restored.
So did the appellant file a full, final, and appealable, or attach a full, final, and appealable order with its brief? Because I just see the analysis that the judge made about restoring immunity, not a full analysis, which would probably be in another journal entry.
Well, the initial, when we filed our supplemental motion on remand, we incorporated by reference our original motion for summary judgments, which moved on everything, that the initial, that there is no exception to immunity. The court, in its order, referenced that it already determined that there was an exception to immunity and focused its analysis on whether .03 would restore it.
Right, so they referenced another journal entry, so we would have to have two journal entries for the final appealable order.
That order should be, it's part of the record, Your Honor. I would say that it's incorporated, it's before this court.
But isn't it required to be attached to your brief? And if it's not attached, shouldn't we dismiss this case?
No, I would say it should not be dismissed because by reference in the order, it's talking, the trial court has put in its order that's before this court that immunity is not imposed on, or that the political subdivision is not immune from liability. So that issue is before this court, whether the political subdivision, the Board of Education has immunity. That was, the court determined that there is no immunity in that order.
So that previous order is also being appealed?
No, this order is being,
So your position is only this one portion of the analysis that the judge did here is what's being appealed?
well, the court focused its analysis on whether .03 would restore immunity. It still ultimately determined that there was an exception to immunity because it referenced it in its order. And the only way you can get to .03 is if there's an exception to immunity under .02. So
you're saying that issue has been decided in the previous case?
correct. So looking at the statute itself, that is the only statute that plaintiffs have alleged the board violated is 4112.02G. Looking at the definition statutes, while persons are defined as political subdivisions, persons cannot violate 4112.02G. This court should follow the only other district court case in Orin, 6th District, which dealt with this issue, and it found that 4112.02G does not expressly impose liability against the political subdivision. even if there was some way to read in that shows it expressly implies liability, there's still no evidence on the actual violation of the statute in this case. Appellants have to show a prima facie showing of discrimination based on race or disability, and there is none in the record.
Aren't the kids involved, either black or brown or disabled or IEP?
Correct.
IEPs?
They still have to show disparate treatment.
And they were the only ones that were zeroed in on for this person who was in the school?
Correct.
So doesn't that get you a potential jury question?
No, because there still has to be evidence that there were instances where undisabled or white children were specifically not targeted. The only evidence in this case is that the children happen to have IEPs or happen to be African American, but there's no evidence that there was some sort of discrimination on the part of the school district that this was actually happening just for the reason of their status. So I would say, no, it's not an issue. There still needs to be a prima facie showing, which there isn't. And finally, I would rely on the briefing for reestablishment of immunity under .03 or .03A3 and 5. However, this was discretionary, and immunity should apply. I think this court should focus on, and my arguments today are that there is no exception on immunity. The clear language of the statute does not expressly impose liability against the political
Why are
sector.
schools not a public accommodation?
Well, the case, there was this court's case in our reply brief that's cited, discussed that difference between what's a public accommodation in an ADA claim versus 4112.02G. The court said that based on the definition in 41, the entire section 4112, that essentially that it's more of a narrow definition. It does not include school districts. While the ADA is a federal statute that's more broad.
I was looking at 4112.019, place of public accommodation, eventually get to or any other place of public accommodation or amusement. Why did that not fit a school district?
Well, because
Specifically, okay, this is an ADA case, I get it, fine, that's over that we can look at for analysis purposes, but.
well, I think the claims in this case are, the whole crux of Appellee's argument is that the school district should have not let certain people into the school district. So to say it's not a public accommodation would be like a store. The examples that are referenced, they have to be similar to that. Places where individuals go that's open to the general public. A school is not open to the general public. Obviously, this whole case is about whether or not someone shouldn't have been let into the school. So it's not open to anyone. And that's what I would say the distinction is. Now maybe the ADA has a different definition, a more broad definition. But at least under how a public accommodation is applied under Ohio's anti-discrimination statute, a school district is not a place of a public accommodation.
Counsel, the trial court in the first appeal, though, determined that there was an issue of fact in regard to that. Or it didn't apply.
In regard to whether there's discrimination, yes.
Well, my point is, I know I wrote a concurrence and dissent in this, and I said that the public accommodation, that particular section didn't impose specific liability on the school district. But I guess what I'm saying is, how's that issue even in front of us now? Because of the fact that the trial court did make that ruling in the previous, and this court didn't reverse on that and didn't say that the trial court was wrong, sent it back just to look at affirmative defenses. So how's that issue even in front of us? In my dissent, I say we shouldn't send it back because that should be done already. But nonetheless, the majority did send it back, so I'm just not sure how it's all in front of us again.
In about a minute of time.
Sorry.
Sure.
And we're answering the
That's
question.
okay. Well, I think we're here on de novo, of course, on de novo review. In order to have an exception to immunity to apply under the statute, there has to be evidence that there's a violation of that statute as a fundamental issue. So I think it's
I
before the
understand
court.
it, but what I'm saying is, since the court didn't send it, didn't reverse on that issue, but sent it back and said, all you need to do is look at defenses, how can you relitigate that now?
Because the court in its order referenced how it initially made that determination, and I would argue that it's incorporated by reference, that in order to get to .03, which was on remand, what it was focusing its analysis on, it had to still go through .02, because you can't have .03 without .02. And with that, I would, again, state that this court should reverse the trial court's decision and find immunity for the appellant Akron City School District Board of Education. Thank you.
Thank you. We have the remaining time for
Please, the court, my name is Ed Gilbert, I represent the appellees in this case. We would urge the court to affirm the trial court ruling in this case for a number of reasons. This court sent this matter back to the lower court for one specific reason, and that was the Tier 3 immunity analysis needed to be complete, and that was it. We have briefed this case back and forth, quite frankly, to death, and that's the only thing that's before this court. The defendant would continue to raise issues and want this matter relitigated time and time again. The trial court completed its analysis by specifically indicating that looking at 2744.03, that there are 7 defenses there. And in our briefing, we agreed that there are 7 defenses there. We agreed that in the briefing that 3 and 5 were the only issues left for the court to consider. The court made a straightforward determination here that in looking at issue number 5, that clearly that was already handled because the trial court concluded and this court sustained that it was wanton, and the jury could determine whether there was wanton recklessness on the part of the defendants, and so that handles 5. So we go to number 3, and the court specifically looked at this, and the facts are quite clear, and that is even with the testimony of Mr. James, the superintendent, which we attached to our brief below, was quite clear that this is not a policy-making or planning issue that these particular teachers and principal were reviewing. They were dealing with long-established policy and procedure of the district. And I think James said it best. He says, we always try to be on one same page. And there was no issue here in regards to whether there was a discretionary interpretation of the rules. The rules were quite clear. We laid that out in page 5 of our brief below, all the different instances where where the principal and the teachers went astray of the actual policy that's been on board for years. And Mr. James admits that they violate that policy, and there's no discretion or deviation from that. And that settles the issue. Boom, that's it. And to go back and talk about, is there any type of issue in regards to discrimination and so forth, I think that's done. That's a jury question, and we should be allowed to go to a jury and make that determination. We feel clearly, looking at 4112, that there is no immunity for discrimination. I think that's insane to sit here and say that, hey, we can discriminate as a teaching faculty, as a principal, as we see fit, and we just walk away with immunity. Well, that's not before us anyway. What's before us is what this court has said. They wanted Tier 3 to be analyzed. It was analyzed. The court analyzed it very clearly. There's no dispute about it, and we went through this whole process. There was wanton recklessness here. That's not before us. The issue of whether there is any type of school public accommodation is not before us. What's before us is whether there was an analyzation of 2744.03, and there was. The court has concluded
And
that.
certainly, but let me ask you this, Mr. Gilbert. Of course, we'll decide whether the issue of public accommodation is before us or not. But if we do decide that, why are schools public accommodation under the statute?
It's a public institution. That's why they have what they call learning centers. It's open to the public. That's why they allow the public in there with certain limitations, like anywhere else. You know, you gotta be able to come in there, and you gotta show your ID and so forth. That's where we educate our students, our children. And I'm not aware of anything, and we will, I think we touched on that a little bit on our brief, but that didn't come all the way in our prior briefs. I know we went through that in depth, but that was not before, so we didn't do another analysis of that. But it's a public accommodation because it's there for the public, taxpayers' money. We all are supposed to be welcome there. We're not supposed to be told that just because you're black you can't come in. We're not supposed to be told just because you're disabled you can't come in. It's open to everyone. And for anybody to say it's not a public accommodation and that we can just walk around and say, yeah, you're out, and you're healthy, you can come in, you're disabled, you can't come in, you're brown, you can't come in, I think that really, I'm embarrassed by having to really argue the issue, you know, because quite frankly, I think we have taxpayers that pay for the right to have their children go to these institutions, and it should be open to all. And that's the way the law is. And I didn't come necessarily prepared to argue that particular issue, but...
And I appreciate in your previous briefs, to the extent
Yes.
anyone argued it before,
Right.
it was argued before, and I appreciate all that.
Right.
I asked you the question, just giving you the courtesy to
Right,
respond
sure.
to the question.
Thank you, but our feeling is that the trial court below did its job. You sent it back, you said do this, it was done, it was thoroughly examined, and now we're up here again, in my opinion, just to waste time and to drag this whole matter out for these poor kids are still suffering for what happened to them. And it is, and, you know, I've been practicing for a long time, I know you've been on the bench for a long time, and I gotta tell you, this is as bad as it gets. And it's time to bring this to conclusion, to have a jury make the call fully on this case, and for the public to be aware of really what happened, and there should be a conclusion of this. What you sent back was done, and it was done properly. That's before you now, and our contention is that it should be affirmed. Thank you.
Thank you.
So the issue of immunity is still before this court, and that's a three-pronged process. So, you know, while the trial court's analysis on remand was to look at that last prong, whether .03 was reestablishes immunity, the issue whether immunity applies is still before this court. The trial court has denied immunity to the political subdivision, to the city, to the Board of Education.
Right, well, then that leads me back to my original question. Did you attach a final order if you didn't attach the other part of this?
We did, because it was the order that denied, it was denying immunity. Whether
But
the
the
analysis,
first part of the analysis that the judge made, that states all of her reasoning, isn't attached.
we're still here on this de novo review, so that we have a denial of immunity in this issue. So I would argue it's whether the Board of Education is immune or not is before this court.
But I'm
And
saying,
still has to go through that entire
if
analysis.
you don't have the full final appealable order, and if it's multiple documents, then we would dismiss your appeal. Right? So should we dismiss your appeal if the full final order isn't attached here?
No, because it's still before this court, and there's still an order that's before the court denying our motion for summary judgment, which is what we filed. We filed a supplemental motion for summary judgment on everything, not just on .03, but on .02, and the court did not address that. It did not strike our supplemental motion for summary judgment, but it just focused its analysis on .03. So by the trial court's refusal to rule on our supplemental motion for summary judgment, which we were allowed to do under the rules, there was no final pretrial or trial set, we were allowed to file that at any time, and the court's refusal to incorporate that into the order denying immunity, we can't control that, so it's still a final order denying our supplemental motion for summary judgment. Not just on .03, but on everything, on .02, there's no exception, which was our original argument the first time up, is we don't even need to get to .03 because there's no exception to immunity that applies. In terms of the discretionary, I mean, that was brought up, I mean, really the issue is there's no exception to immunity, and this court should go no further and find that 4112.02G does not expressly impose liability against the political subdivision. That, again, I would urge the court to find immunity for appellant. Thank you.
Thank you. The court will take the matter under advisement, issue a decision in due course. When that decision is released, it will be mailed to you by the clerk of courts and also posted on the High Supreme Court website.
Thank you.
With that, I'd like to thank both of you for your presentation today on behalf of the court.
Thank you.
Thank you.